Um, Good morning, Pat and Sandra. I'm really glad that you're taking part in the course today. This course is kind of an abbreviated course that I actually run for Indigenous Services Canada and for AFOA Canada. A few years back, there was a recognition that there was a real um, piece missing in our communities. And so, uh, because I have this special designation, it's called an MTI. It's a specialist in trust and estates. I was asked to provide the training. I actually like this type of course better than actually doing a training because I train the people in the community that are going to help with estates. So this is fun because it's about you and about individuals. So I don't think you need to see who this is because you basically know who I am. I've been out to the community so much. I'm beginning to think I need to get a house there. I do caution people that this course is generic. I am going to identify specifically to Ontario today, but it is governed by the province that you live in, and you're going to learn about domicile. Um, is really important when you're dealing with your estate. Um, Indigenous Services Canada, or better yet, the Indian Act, actually looks after us who live on reserve. And so, um, Doreen, can you get someone to close my door, please? So this course is going to talk about if you live on reserve or off reserve, and there is a really big distinction between the two. And there's a big difference because if you live off of reserve, your the province of Ontario or the province that you live in, your will and what you're subject to is ruled by the province. But if you're on reserve, it's actually the Indian Act, and it's really kind of disappointing because when you look at the different legislation the between between Jacob Pine needs out. Sorry, guys, about this. Between the provincial legislation is there. They have the Wills Act, they have the Powers of Attorney Act, they have the Trustees Act, and in the actual Indian Act, we only have a couple of paragraphs. So it kind of sucks that not more attention is paid to what us as Indigenous individuals administering our estates. Now, what is an estate? I always tease people when they're sitting in a room with me. I'm saying, do you have clothes on? Because if you have clothes on today, you have an estate. Because a lot of people, I know, like my mom and my dad, before they pass on, they go, well, we really don't own anything. We don't have a lot. But if you have clothes on your back, you actually have an estate, and you have to be aware that dealing with your estate is kind of an important responsibility all of us have as individuals. So I wanted to let's start by looking at our estate, and a good place to start is if you own a house, there's things in the house that need to be dealt with when you pass on. And I'm always tell, especially women are more sensitive about this than men, but you need to kind of walk around your house and look at what you own. And if you have a certain picture or your wedding bands, or maybe your mother's china, and you want that to go to a certain individual, then it's really important that you make a list of the things that you want to be given to a certain individual. Now, I know that a lot of people will go and write on the back, well, names can be crossed out or inked out or things like that. And I really hate the sticker thing. It doesn't work. Making a list of your personal items is important, especially if you have minors. And I always use this example. When I was 4, my my parents' house burnt down, was actually me in it, and they died and I survived. And there wasn't anything really of sentimental value for me to have. But as I've grown older and I've collected things of my own, there's things that I know that I would like my sons to have. And they always want to fight over this one picture, and I don't want them to fight. So I'm going to make the decision as to who gets what, why, where, and when. So I tell people, if you're making this list, use a day like today where it's rainy and cold and kind of gray, because when you're walking around and looking at, who am I going to give things to, it can really kind of affect your mood and your sentimentality. But the biggest fights with administering estates, and I've acted as an executor on many cases, is usually over the personal items. And so that's really, really important that we have this list and kind of have this set aside with our will. Now, when we go on with an inventory, we really have to look at what we own. And so, like in my community, we have lease and lease properties. And if you looked at the last picture, that's actually no, it's not that one. It's the one before. This is actually my house in my community. But if if you have CP land, certificate of possession, or you have lease land, and this is not a home that you've rented from from Whitefish River, or it isn't a home that you have maybe in Espanola, then you have to look at that ownership, and you have to look at how you want to deal with that. The same thing with bank accounts and pensions and retirement savings accounts. You have to look at everything you own and kind of make sure that you kind of make a list of it and know where things are and how they're owned, because how they're owned is important. And we're going to talk about that in a few slides, because there's certain things that will you need to put in your will and address. And there's certain things that you don't need to put in your will and you don't need to address. And we're going to kind of talk about that in a bit. So it's important to make a list of where everything is that you owe. So, if I have accounts at, let's say, at the Bank of Montreal and the Royal Bank and Peace Hills Trust, then, I need to make a list and let the kids know where, what the account numbers are and the type of accounts. Because what happens is, if you pass away and you don't have a list of, this is where my bank account is, this is, who my pension is with, this is who I have my life insurance with, it's kind of like a hunt and peck. It's I always think of it as like an Easter egg hunt, when you're going out to trying to find all the different colored eggs. It's like that. Your kids are going to have to go in the house, and they're going to have to go through all your different possessions and try and find things like where you bank and your pension. If you belong to an association also, that's really important that you record that. I am a veteran, So when I pass away, my family receives $10,000 for me as a vet, to help with the funeral. There's different colleges, like with the Chartered Public Accountants Association. They actually have a life insurance that they give to their members, and that. So, if you have all those kind of little extra special things, you need to make sure that is recorded too. So in your list, you have all your bank accounts, all your savings accounts, you have your life insurance, your pensions, any associations you belong to. And a lot of people don't think about it, but I'm really sensitive to it. We have these points cards now. So if you go to the grocery store in Espanola, they have it's an Optimum card. And there's Aeroplans, and there's points with credit cards and that. And some of us build up quite a lot of points and we never use them. And those are actually transferable at death. So you need to make a list of where, what cards you have and what points are associated with those cards. And even I go as far as identity theft at death is huge nowadays. It's unreal how much it's happening. And a lot of people that are stealing identities are stealing them from going into the obits and getting all the information they can get, or going to cemeteries and looking for recent deaths. And by failing to cancel things like Nexus cards or passports, or even your status card, that's really important. We need to be making sure that we're recording. This is my passport. This is my number. This is the expiry date. This is my status card. This is all my information. Otherwise, it's, if you've ever administered a state, you're kind of hunting and pecking and trying to find what it is, is encompasses your estate. I had an elderly aunt, believe it or not, and she passed away, and she named me as the executor, and I didn't know, and so I had to go into her house, and like, she had jewelry in her dainties drawer, in her underwear drawer. She had, documents in freezers. It was absolutely crazy. There's really cool accordion files you can buy now that at Costco, where you can put all the important documents. And I actually have one. It's a little box about, I don't know if you can see my hands, about this big. And I have on it in case of emergency, it's everything is in there. I try and keep the most recent tax returns and bank statements. I try and refresh it if there's any major changes. When you've made these lists out, it's really important that you make copies. So what I have is, I have my will. I have my original will, and we're going to talk about where I keep my original will. And with it, I have my list, but I also have given my sons copies of lists. You never know. You may be traveling with, one of your children, and something happens. So it's good for them to have. And my boys, I always laugh, because what I do is I give them a sealed envelope, and then we exchange it, and they haven't, they're not in there, examining everything. The envelopes, you can seal them so you can tell if they've been opened or not. Or if you're not comfortable, give them to someone you are comfortable giving it to, and have them, you tell your kids, if something happens to me, go and see Pat. She has all my information. Now, if you have any questions, Jacob is allowing you just to ask the question. So you can put your hand up or unmute yourself and ask the question. Stop me at any time. I'm happy to answer the question. I'm also going to be out in the community Saturday, Sunday, Monday, and Tuesday. So if you need to talk to me about something particular to your situation, make sure you come by and I'll sit down and have a visit with you and talk to you about it. Now, review retirement accounts. There's an absolutely major lawsuit going on right now between a family and their son's ex-wife. And what happened is, he got busy and he forgot to change the designated beneficiaries on his RSPs and on his pension to his family. And when we get into what's probatable and non-probatable, I'm going to give you some little tips. But you have to make sure that, and nowadays it's so common, we have blended families or multiple marriages that we have to be aware of this and paying attention to it, because if we don't, then the wrong party can get the funds. Now, if you are single and you have children, and your children are minors, you're best to put your estate as receiving the funds. And then when the estate receives the funds, they'll go into trust for your children. If you don't do that, then either ISK or the public trustee will come into play. It's the same as with our minors trust. Children under 18 are not legally entitled to receive large sums of money. It has to be held in trust. And so when you prepare your will, we're going to talk a bit about minors and putting their shares in trust. Now, simplify your affairs, and this is really super important. Is if you're like me, and like, here's a good example is I started my career with Royal Bank, then went to CIBC, and then came to Peace Hills. And banks have this policy that if you work for them, you have to have a bank account with them. And so I have an account at Royal, I have an account at CIBC, and I have an account at Peace Hills. And, I don't need to have those three accounts. So what you need to start doing is consolidating everything you have over everywhere, because banks can be a bit challenging on when someone passes to deal with. And same with pension funds. Like I used to have an RSP, my personal one. I think it was at a private investment company, and then I had my pension, and then I had this, and they had that. And recently, now that I'm getting older, I have consolidated everything into kind of together into one financial institution. I think one or two is not a big deal, but if you're like some people, I've dealt with some estates where they've had accounts in 6 different banks, and that adds to cost and difficulty in actually administering your estate. So the next slide is the slide we're probably going to talk quite a bit about, and that's my granddaughter. It's nice to see the lyre in the snow. This is really the most important part of your estate administration, and it's what will go in your will and what will not go in your will. So if you see on the one side, there's a green side, it says probatable assets. Whoops, you can't do that, Georgina, because it says probatable assets. So probatable assets are the assets that will go through your will. Anything that's non-probatable does not go through your will. So what does probate mean? Jacob, can you open my door a little bit? Probate is I've passed away, and everything I own in my own name or anything where I've designated my estate as the beneficiary, or vehicles or personal items or businesses, those go through my will. And when I die, what happens is my executor will gather and make a list of everything I own in my own name, and how much it's worth. And they'll send that list along with my will to the court or to ISK. And ISK or the court will say, yes, this is the last will and testament of Georgina. And yes, Doreen is her executor. And so that gives Doreen the power to go around and deal with my estates. So we have to be careful now. All assets solely in your own name. So a lot of women, I remember when I got married, my dad gave me $500, and he said, put this in a bank account, and if you ever need to come home, you've got money to do it, and don't let your husband know you have it. And it's quite common that women have those type of accounts. I like to call them runaway accounts. So if you have an account with just a little bit amount money in it, be aware, and it's in your own name, that could be a probatable asset to you. Real property, so that's property you own in your own name or tenants in common. And so let's talk about things solely in my own name. Is Georgina owns it. Tenants in common is a fancy way, and you see that quite often. Property is owned tenants in common when you have second marriage. It's he owns 50% of the house and I own 50% of the house. So tenants in common is kind of, if you still own it in your own name, but it means more a portion of something that you own. RSPs, risks, life insurance, pensions, if they have a designated beneficiary or it names the estate as a beneficiary, then that is a probatable asset. So if you have a second marriage and you want to ensure that your TFSA and your pensions are going to your children, and certain things are happening, then it's best to say estate, especially if you have a minor. All you have to do is put the word estate. And then what happens is who's ever administering your pension plan or your life insurance policies or your RRSP, they're the ones that are know to pay this money to the executor, and then it'll be the executor's job to deal with it. Vehicles is really common. We have vehicles in our own name, personal items, and businesses. Now, businesses, a corporation is a separate entity from your estate, and it will require probating. And the nature of your business, whether it be, doesn't matter whether it's a partnership or a corporation, you still have to deal with that through your will. Now, the biggest thing that most people do as we get older, I married my husband. I've been married forever. I'm leaving everything to him. Then, so that you don't have to probate anything or send anything to the court, you can own things jointly. So if I own something jointly with somebody else, that passes with right of survivorship. So if I have a bank account and it has my name and my husband's name on it, and it's a joint account, that means as soon as I die, all he has to do is go in with the death certificate and they remove his name. Now, you do have to be careful with joint with right of survivorship, because what joint with right of survivorship means is a lot of people think, well, you know what, I'm going to make, I have this account, I'm good with my friend. It's not a big deal. It's joint of right of survivorship. If something happens to me, she's going to get 50% of the money and I'm going to get 50% of the money. That's not joint with writer survivorship. Joint of writer survivorship. So let's say I have $10,000 in a bank account and I own it jointly with Chantel, just turned her camera on with Chantel. Then what that means is I own 100% of that money, that 10,000, and she owns 100% of that 10,000. If I die, it goes to her. If she dies, it comes to me. RSPs, risks, life insurance policies, if you've named your children on them, and your children are minors, then the insurance, they don't go through your will, and that's a big problem because minors again cannot receive money. Minor shares have to go into what's called a testamentary trust. So if I have a life insurance policy and I've named my two sons, Mark and Jason, 50% each to receive my money, and they're minors, what the life insurance company is going to do is they're going to pay that to the public trustee or to ISK. So I really recommend, if you have minor children, to make sure it goes through your estate, it goes through your will. And then in your will, you can say, well, you know what, my whole estate is worth 300,000. I want it to be divided between my two sons, and until they turn of age, these funds are to be used to care for them. But when they turn 18, maybe they get all the money, or if you're like me, you're scared with them getting a large sum of money. So you give them 25% at 18, maybe 25% at 20, and the other 50% at 25. I don't know. That's a very personal thing. But when you're dealing with minors, you really have to be very, very careful of how you're gifting anything to them, even personal items. Personal items have to be cared for. If I'm a minor and I pass away, my wedding bands would have to be, and my wedding rings would have to be held aside until I was old enough or mature enough to not lose those rings. So it seems crazy that those two little categories can really upset your estate, and they can. So just remember, everything that you own in your own name or you've designated as a beneficiary, that goes through your will. Anything that you own jointly or you put a designated beneficiary like your husband, it goes directly to them and it doesn't go through your will. Any questions before I go on? No? All right. We're going to go to the next slide then. So this is, Jacob and I had the honor of doing a session, this exact session, for an elders group in Saskatchewan last year. And we asked the people in the group, how many of them do you have a will? And there was very few people actually put up their hand. And a lot of people said, well, they don't want to do the will. And the reason they don't want to do a will is because they're scared. If I do a will, I'm going to die right away. Well, that's never happened. I've written over 450 wills in my lifetime, and no one died immediately afterwards. So a will is a legal document that is only in force as long as you are alive. And you can write your will, and if you decide change your mind, and let's say Doreen has been a horrible daughter and you're going to cut her out of the will because she's an awful person, well, then all you have to do is tear up your will, that voids it, or you write a new will and you put a statement in it that says you revoke former wills. So, if you write a will, you could write one every day if you want, but if you write a will, it remains in force until your death, unless you tear it up or revoke it. Now, I know I've been out to the community a lot. We've talked about there's 3 groups. There's also 3 groups in a will. And if I'm writing my will, I'm called the testator or testatrix. I'm the person, the deceased person that's making the will. I provide directions, and the directions are to my executor on how to give items to the beneficiaries. So I'm the testator and the person that's writing the will. I provide directions to an executor, and the executor is the person who is going to administer the will. Now, I do want to talk to you a bit about who you're going to name as your executor. So your executor is the person that's going to administer your affairs if you die. So that person is not always just your oldest child. Like I know that when I was having to article to get my MTI, the oldest person, whenever I met with an elder, they always just said, well, my oldest child is going to be the executor. Well, you know what? Is that the right person to administer your estate? Maybe you live in Little Birch and, your oldest child lives in Vancouver. Is that the right person to be administering your estate? No. So you have to kind of look at your options of who you're going to name to administer your estate. And I kind of want to remind you is if your 2 children do not get along now, they're not going to, that's not going to help things when you pass away. Naming them isn't going to bring them together. It could actually cause more problems. And if you've been around like I have for a while, you know that estates can get quite ugly and quite difficult to administer. So when you're looking at your executor, look at someone that will get the job done and get it done with the least amount of conflict and hopefully, with some type of impartiality. Now, if I'm your daughter, it doesn't mean I can't be your executor. I can. And maybe I can be it with my sister or my brother, but maybe you just want one child. But when you're administering setting up your executor, you always want to pick a couple of people. Well, so I say, well, I'm going to pick Chantal to be my executor. And if Chantal is not able, or she's unwilling, or she's not mentally capable to do it, then I'm going to pick Sandra. And so you can have a primary, you can have an alternate, or you can have them joint. If you're picking Georgina and Doreen to do it together, you want to say jointly. And then if something happens to Doreen, then I'm administering on my own. The other thing that I kind of want to talk about on this slide, which is really important, is if I'm divorced and my will isn't canceled and my obligations to my ex-husband isn't canceled, unless I have what's called a separation agreement, and that's a whole other course. But if you are divorced and all you have is the divorce decree, that doesn't mean that your ex-husband may not still have a claim on your estate. You need to have a separation agreement where you've waived each other's rights to each other's estate. and we see this a lot nowadays with common law people. I have an ex-husband. Don't have a separation agreement. I'm living common law with someone else. I've been with them a few years. What can actually happen is I can end up with two spouses. So you have to be really careful when you're if you have a multiple relationship, or multiple marriages. If you're getting remarried, and you don't say in contemplation to marrying Billy Bob, if you don't say that, then the minute you say I do, your will is canceled. So I always say, you know what, do a will just before you're married, and as soon as you're married, or do it in contemplation. You have to be very, very careful in all these situations. So any questions there? And it's much easier when you're doing this in person, and maybe Leslie will want me to do it again in the community in person, because then, we can look at different situations. Because right now, I don't know who's had one married or multiple marriages. Now, the other one is domicile. Domicile is really, really important when you're preparing your will. If I live on reserve, then I'm considered domicile on a reserve. If I'm off reserve, then I'm considered domicile in that province. Now, the big thing for status Indians, it's who is ordinarily resident on reserve, and that ordinarily resident on reserve is a big question. So if you're like me, I have a lease property in Morley, my community. I have a lease property there, and that property is mine. It's 100 years lease, so I can will it to someone. But ordinarily on reserve doesn't mean that because I go home every weekend to be in my house, it doesn't mean I'm ordinarily on reserve, because I'm not living there full time. Now, if you're ordinarily on reserve and you get taken to a nursing home, that's not by choice. So you would be still deemed to have passed away on reserve. And now the big thing is we have to be really careful. So I don't know how many of you've been to Banff, but if you've gone to Banff, you've drove right through my community, believe it or not. And my community, we have reserve land, we have a national park land, provincial park lands, and we actually have reserve lands. So you have to be careful. And I don't know if Birch Island has provincial parkland that is considered part of theirs, but you have to be aware that. So if I pass away in my house and I've been living ordinarily on reserve in Morley, then ISK will look after my affairs. So instead of going to the court, it's actually a lot cheaper and much easier if you live on reserve and you're dealing with your estate. Then you just deal with your every province has a local chapter, an estate office through Indigenous Services Canada. And you guys are really lucky out there in Birch Island, because the estate office, head office, is actually right there in Sudbury. So that is good for you guys. And I have all the numbers and that with just be aware that if you pass away on reserve and your will goes to ISK, it has to be the original will, and it has to be an original death certificate. So you know what? It's a piece of paper. And funeral homes, they make me mad. They want to charge you per death certificate, and they shouldn't be, because they're just printing out more and signing it. Like, give me a break. So I always tell people, get lots and lots of death certificates from the funeral home, so that when you're sending your will into ISK and the death certificate to receive the grant of probate, then you send the will and the death certificate. And since we're talking about that, let's talk about what happens if we don't have a will. What happens if we don't have a will? We're in deep doo-doo. And I don't, that's what I used to tell my kids. So I don't know if that's a proper English or even a proper word, but you're in big trouble, especially if you have minors. Like, who's going to be the guardian? How's their money going to be looked after? You and your husband die together. Like, you've got all these situations to look at. But if you die without a will, just be aware that it's the province. If you're off reserve, it's the province deciding how your estate is divided. And if you die on reserve, then it's actually ISK deciding how your estate is divided. And believe it or not, if you live in Ontario and you pass away off reserve with a will, your husband only gets the first 200,000 and the rest he has to share with your kids. So that could cause some real financial hardships for your husband. So we never want to die without a will. It's called dying intestate. And then instead of applying for grant of probate, you're applying for something else. Now, let's look at the type of wills. There are three main types of wills: attested wills, holographic wills, and notarial wills. We're not going to talk about notarial wills. Notarial wills are wills that are prepared in Quebec by a notary, which is kind of good. But an attested will is a will that is entirely typed in your own hands. And we're going to talk about attested wills and holographic wills. But I want to talk to you a bit about, those, you go to my friend told me, she says she paid $10 at the post office to get a will kit. And I said, oh, can I see it? And she gave it to me and I threw it in the garbage because there's a lot of confusion. And what happened is when you have that fill in the blank will kit, you can actually make mistakes. And if it isn't signed properly, it's not legal. So I'm not a big fan. If I had a choice between an entirely typed will by myself or by a lawyer or a holographic will, I would definitely pick one of those. I would not go with one of those fill in the blank wills. You know what? Those things, the only people that are making money on the fill in the blank wills are the lawyers, because they're having to go to court to fix these fill in the blank wills. So we don't want to do that. Okay. So let's talk about an attested will or formal will. An attested will is the most common type of will. It is sometimes also referred to as a formal will. Attested means that it's signed by witnesses. So an attested will is a will that's entirely typed. It's dated and signed by the testator, that's you, that's going to pass away, and two witnesses. And each page is initialed. So you can't, do you see what I'm saying? An attested will is a will that's entirely typed. Well, fill in the blank wills aren't. So it's entirely typed. It's signed by two witnesses, dated and signed by two witnesses. And the witnesses, they have to be people that know you. You're not going to walk up to a stranger or you know what? Hey, I know Leslie at the band office. And you know what? Leslie doesn't really know me that well, but I'm going to get her to witness my will. Well, Leslie may not know that, you have early signs of Alzheimer's or some kind of mental disability. So it can't be family members. Actually, it's funny. Here's a funny story is when Jacob came to work for me, and you guys all know Jacob because he's been out to the community a lot. He told me he did his dad's will and he was the executor and the witness. Well, you can't be the executor, the beneficiary, and the witness. So if you have a will, it has to be two people that are not your executor and are not going to receive something in your will. All right. And it's good if they kind of know you, because when you pass away, one of them, not both, just one is going to swear that you weren't not so when you signed that will, that you were sign, mind, and body, as they like to say. So an attested will is a will entirely in your own handwriting, dated and signed by you. Now, with attested wills, you have to initial each page. If you don't initial each page, it would be really easy for me to slip in a new page. So when the court is looking at the will or ISK, they're going to want to see the bottom of each page initialed. And you remember at the beginning of this presentation, I said, you got to walk around your house and figure out, what it is that you want to give. So I want to give this painting that's behind me here to my granddaughter. If I date and sign that list at the same time I date and sign my will, that list is legally binding. And I like that, because if I want to know for sure that my wedding ring and my engagement ring goes to my granddaughter, nobody else, I can either write it in the will or I can put it in the list. If I put it in the list, not dated and signed at the same time as my will, not legally binding. Dated and signed at the same time my will, legally binding. Now, there's something that's called a holographic will. And in Ontario, a holographic will is a will entirely in your own handwriting, dated and signed by you. You don't need to have a witness with a holographic will. What's going to happen is the court is going to look at your signatures and see if they match other signatures. So a holographic will is a will that is dated and signed by you, and it must be all in your own handwriting. So if you do one of those fill in the blanks and you don't have two witnesses, it's not legal. Now, for me, if you have nothing, a holographic will is better than nothing. And we see a lot of people, they don't have time to get to the lawyer. They're going to go to the States. If they get in an accident, they want to know their affairs are looked after. They'll do a holographic will. If you are, I suggest you get an expert like myself or somebody else to look at it, because, if you miss to date it or you miss something in it, it could cause, you could have a will, but you'd be having to do, maybe you'd have a will, but no executor. You'd have a will and, maybe one of the people in your will have passed on. So it's a big issue. Now, with formal requirements in the will, you have to start by giving your full name. So, I give my full name. I give my place of residence. I usually say I'm of sound mind and that this is my last will and testament. And if you have a will that you've done before, you want to say, I revoke all former wills made by me. You want to give the full name of the executor, and an alternative, just in case something happens to that executor. Now, with funeral wishes, I've never been a big fan of putting funeral wishes in a will. And this is a personal thing, and it always is a personal thing. I think you're usually dead, buried, and long gone before they look at the will. So maybe your wishes put in the will are not the best way. I'm going to tell you, my poor kids, imagine, being my kids and, being in this type of expert. I've told my kids is if something happens to me, make sure you cremate me and throw me on, on the land in Morley. So that basically I always tell them, toast me and toss me. I want to know that they're aware of what I want. I think that it's not fun to talk to your kids about it, but it is better to talk to them about it than not talk to them at all. Again, if you have specific items, put that down in a list. If you have any specific gifts, so let's look at an estate as a piece of pie, right? This piece of pie, I'm going to give my rings and certain household items to my certain people in my family. And then because, Jacob has always been a good kid and I've always really liked Jacob, I'm going to give him 10,000. That's called a special bequest. And maybe I'm going to give my really old cheap Hyundai to Chantel. Those are specific bequests. You can do that. But if you say, well, I'm giving 10,000 to Jacob, what happens if Jacob's dead? Does it go back into the pie, or does it go to his wife or his kids? Then after you've done the special bequest, you have the rest and residue. That's what's left over. You always want to address the rest and residue. That's what's left over. And so if I leave something to Marco, my one son, leave 50% to Marco and leave 50% to Jason, I have to say what happens if something happens. And, Marco has a daughter. So if he passes away, I want his share to go to my granddaughter. Jason has no children yet. So maybe Jason's share will go to Marco or to his wife. You know what? You can do with it whatever you want. But when you're doing a will, you always want to do the what ifs. Now, this is really, 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 really important. Your will is your last message to your family. And I wish we were in a room, because I always get people to put their hands up, and they, you always hear about mom passed away without a will and what a mess the estate was. And you always hear those kind of stories in communities. It's so simple to do a will. It's so cheap to do a will that you know what? It's important to do it. And if you can afford to go out for dinner one night, then you can afford to have a will. If you can't, then let's write one out and have someone just look at it and maybe give you some good tips. But it's better to have a will than not have one. Now, I'm going to quickly touch on two other areas. I know I'm running out of time. So a lot of us, thank God for medical science. And, in my parents' day, people died really, really young because, quite honestly, there just wasn't the medical science, that we needed. Nowadays, there is, we live, for forever. I think Leslie started it. Your oldest member in your community is 93 years of age. Wow, what a great age. So we need a document that's called a power of attorney. And what a power of attorney is, it's a legal document that allows someone to look after my finances. So if I get in an accident and I'm going to be in the hospital and, for a really long time, who's going to look after my financial affairs? As I grow older and I start having issues with my memory and I need to go in a home, who's going to pay the home? Who's going to do my taxes? Who's going to do all of this? A power of attorney is a really important document. If you do not have it, your children either have to go to the ISK and ask them for the right to look after your affairs, or they have to go to the province. And it's a really, really costly thing. So a power of attorney is a legal document that's only good while you are alive. And be careful, because your bank is going to say, well, we're going to give you a power of attorney, but that's a restricted. That's only over that bank account. It's not over your house or your cars or other things. So you need the power of attorney to deal with just the financial you. Now, with the power of attorney, the person that you're appointing has to be 18. And when you're making a power of attorney, you can make up the power of attorney to say, I don't want this document to come into effect until my doctor says I'm no longer competent to deal with my financial affairs. And that's called a springing power of attorney or an enduring a power of attorney. So you can do up a power of attorney today that says, you know what? I'm going to name my son Jason to look after my financial me, but he can't do it until my doctor says he can do it, or two of my friends says he can do it. So you can do it like that. If you're naming one person, it's the same as doing it for a will. Is you're going to want to make sure that you're naming not just one person, but you're also naming an alternative person to do that. So you have I have Chantal and Doreen are my powers of attorney. Now, it's different with powers of attorney. You can say they're going to work together, jointly together, or severally, individually. So if you're naming two people, you have to say whether or not they work together or they don't work together. Or you can say, well, I name Chantal and Doreen jointly, and if they can't do it, then I name Sally. But there's lots of different ways to name people, and you can choose that way yourself, which works best for you. But the power of attorney is really, really important, especially if you own a business. Everything stops, right? Nothing happens. No bills get paid. Nothing gets done, with your financial you, unless you have a power of attorney. And I think this slide got mixed up, but it did. So we're just going to go to the next slide. So the next one is you have a power of attorney for the financial you. So the will is for when you're dead. The power of attorney is for the financial you when you go nuts or you're not. Usually, if you're not physically capable, you can still with your affairs. A power of attorney is more as if I kind of go wingy in the head. Now, the power of attorney, financial, the power of attorney for personal care, I put that in specifically, and I've just got to switch the one slide around. The power of attorney for personal care is what it's called in Ontario. And I made sure I changed this deck yesterday. The power of attorney for personal care is really, really, really important. And the reason it's important is if I get sick, I can tell my family what type of nursing home I want to go to. If I'm in an accident, I could say this is the type of rehabilitation I want. This is, this, and people always think powers of attorney for personal care is about, just, end of life choices, right? But it's not. Power of attorney is really important for before you pass away. And you may be in a nursing home and you're not physically able to care for yourself. This is when this comes into play. And if you have a second marriage, or it's really important that you say who it is that's going to look after the physical you. Now you can name again. This one will not come into this one, with the power of attorney for the financial you can make it springing. Only if the doctor, right, says you can come, it comes into play, or your two friends, or you can make a power of attorney like I have. It comes into force right away. I don't need my sons. I trust that they're not going to start going into my bank accounts unless I am nuts. But the power of attorney for personal care, it comes into effect right away. And it is really, really important that it's in place in Alberta. This is how careful doctors are, is if I don't have a personal care, my husband doesn't have the legal right to say, cut off her leg to save her life. He doesn't have that. So the power of attorney over personal care are extraordinarily important there, because we don't know when something's going to happen. It really lets your family know exactly what you want. And you can get one that's one page. It says, hey, I appoint my two sons to look after me and make decisions jointly or separately. Or you just, but you always want to have a primary and an alternative, or two working together. But with this one, you can get them free. Most justice departments or provincial websites give you the personal care, and some of them are a page long, and some of them are called an advanced healthcare directive. They get really into, this is, if I can't eat, this is, can you withhold food? They get quite detailed, but it's really important when you're looking at your affairs or your estate. And I see Pat has clothes on. So Pat, I know you have an estate because you're wearing clothes today. I always tease people that, if you're not here with clothes on, you've got a problem. But as long as you have clothes, you have an estate. And you need that will if I die. We need that power of attorney to deal over the financial me if I go nuts. And we really need the personal care. And it's funny when you look at it and you talk about it and you discuss it with people. You know what? We'll make sure that the certain things like the furnace is cleaned out at home, or we get our annual physical from our doctor. But something that they actually did a study at Harvard, and Harvard found that the most procrastinated thing in a human being's life is the preparation of a will, a power of attorney, and a personal care directive. And for myself, I make sure that mine is kept really, really current. It's really easy to, well, I'm going to deal with it next week. I'm going to deal with it next week. There is no next week. We don't know for sure when something's going to happen. And when you're doing the designation I have, it takes 7 years to get, but you're required to administer other people's estate, like act as a public executor or public trustee. And I can tell you, I think I settled probably about 200 estates, and the amount of fights, to give you a good example, 3 sisters, a whole pile of costume jewelry, and I had it appraised. It was $75. It took me 6 months to negotiate who was getting what piece of jewelry. So things that we don't think is important, they will. In this family, it was this little, Cracker Jacks box. It was a Snoopy pin that came from the Cracker Jacks box. They were going to kill each other over it. If I could have bought 2 Snoopy pins and given it to them to shut them up, I would have. But it's important. It is beyond important to have our affairs in order. And I don't know how many of you I went to day school. I started school on reserve, and so I received my day school settlement. Some of us have 60 suites, you know, very large settlements. Some of our are residential, you know, with the Robinson Huron Treaty Settlement coming, we're all going to get a PCD, not me, because I'm not from Robinson Huron Treaty. But, you know, it's important that we're looking at this and we're sitting down and we're you know, discussing about what it is that we're going to do to look after our family members. And that, I'm sorry, is a little over an hour. I could have gone on and on and on and on, but I'm not going to. But I do hope you get out there, the couple that got on and watched, and tell people how important it is. And Leslie, if you need me to do this again, it's something you can see I really, really enjoy doing. And it is so very important. But thank you for your time today. And Leslie and the Chiefing Council at Whitefish, you are so progressive of trying to help your members. And I, you know, I think that's why I'm so lucky to work with you.
Great. Thank you, Georgina. Jacob.
Okay. Are there any questions? Otherwise, I'll let you go. I am in the community on Saturday, and you can come if you have any particular questions about your situation. You can come and see me after the community meeting. It ends at 2, right, Leslie? Yeah. Right. Okay. Well, thank you very much.
All right.
I'm going to bring cold weather with me, rain and snow. Bye-bye, guys.
Bye.